Good evening, this is John Milburn for Laws 19038, Planning and Environment Law. It's week 3. And this week's discussion relates to the impact of the common law on planning and environment law. I guess the short answer is that the common law is not nearly as important or significant now as is the case in relation to litigation or legislation rather. And welcome Jade to the course. So we're just starting to record, we've just started to record now. If you have any questions, comments, please feel free to unmute or use the chat facility. As part of the reading for this week, we have something a little different. You'll notice a Zoom session involving myself and others and Judge Morzone QC. At the time that I prepared that Zoom session, His Honour had not been appointed, but of course he is appointed now, and is a person who is appointed to the District Court and has a commission for Planning and Environment Court, and you'll see His Honour's cases figure quite regularly in my commentary that I prepared. Bear in mind, of course, that if you do come across His Honour in the social context, please do not use his first name, as was the case in the video, but use the more customary title of Judge. In court, of course, the correct approach or procedure is to say to Your Honour, rather. Okay, so tonight's session will be quite short, quite simple, and it is based, amongst other things, around the separation of powers. Now, I noticed that we didn't have any responses to problem 2.0, which was the set work for week 2. So I've got to say I'm a bit disappointed. I'd hoped that we'd see some responses to that. I guess one of the problems, I must confess, is that without an examination, I don't have necessarily the fear factor that might otherwise be the case and prompt people to provide some commentary. But I would like to see some comments in relation to the weekly problems. And if you have a look on Moodle, you'll see that I've provided my take on the issue of separation of powers. The reason I've mentioned separation of powers is that in the context of planning and environment law, you need to bear in mind that for the most part, we look initially at legislation, quite rightly, and then we'll look at executive materials, which are part of the delegated legislation regime. And I've put on UCRU, I think, a very good explanation of the delegated legislation regime. So that's at the executive level. And when we're talking about the lawmaking ability at the executive level, we're really talking about things like bylaws, rules, regulations, things of that nature. And bear in mind that the executive only has power to make those rules, regulations, bylaws, planning policy documents as a result of power conferred to it by Parliament. So please keep that in mind. All right, so, and then at the third level, we have the courts, and for the most part, when it comes to dealing with planning and environment court decisions, we'll be talking about decisions in the Queensland context in the Planning and Environment Court, unsurprisingly, which is part of the District Court. Judge Morzone QC is part of that District Court / P&E Court jurisdiction. And most of the decisions that relate to the P&E Court will come as merits appeals, and I'll mention that throughout the course, and I'll do some commentary about that tonight. So, what we're talking about in the common law is really the judge-made law, as opposed to the law that is made by Parliament or the laws that are created through the executive, bylaws, regulations, planning policies, etc. So we're talking now about the impact of the common law, the judge-made law, on planning and environment law. Usually that law comes to us as a result of what we call precedent. And a case decided on one day may form the basis for a judge deciding a similar case the next day, if you understand what I mean. But precedent works on some hierarchy. Of course, a court at one level is bound by decisions of higher courts, generally speaking, and that is in relation to the same factual issues. But when it comes to, say, the Planning and Environment Court, it's a bit different in that all of these matters are dealt with by different judges at the same level, and they're not bound by each other's decisions, but they are persuaded by those decisions. But the other thing is that the decisions in the Planning and Environment Court are very often decisions about particular specific applications, and it's very difficult to necessarily translate a decision in one instance in the Planning and Environment Court to another scenario in the Planning and Environment Court, because each application relates to different aspects of the use of different properties, and therefore from a factual perspective they're not necessarily or generally at all comparable in terms of one decision compared with another. I hope that makes some sense. So anyway, the common law, we're talking about judge-made law. It's that third level of government as opposed to the Parliament and the executive. Now, bear in mind, from a Planning and Environment Court perspective, or from a Planning and Environment Law perspective, people that are unhappy with decisions in relation to planning and environment may have access to complain at three different levels. And I'll just explain this briefly. Firstly, people may be unhappy with legislation, and that legislation is created at a parliamentary level, and they may be unhappy with legislation of general effect, such as the Sustainable Planning Act, or much more specific effect, such as the Sanctuary Code Development Act or the Sanctuary Cove Act back in the 80s. So these are the things that are created at parliamentary level. And you and I, members of the public, we don't have the right to challenge that, generally speaking. There is the constitutional element, but that's really between the states and the Commonwealth for the most part. So generally speaking, parliamentary level, our remedy is to lobby and to seek change, and ultimately at the time of election. To some degree, the same thing applies at the next level down, the executive level. And bear in mind that the executive can only make its rules, regulations, bylaws as a result of power conferred upon it by Parliament. So there is the chance to scrutinise whether, in fact, the executive made those rules, regulations or bylaws in accordance with power that was properly conferred upon it by Parliament. But generally speaking, if a planning policy is introduced, then members of the public don't have the chance to challenge that. And really it's a matter of ensuring from a P&E perspective that submissions are made during the course of that planning policy being considered before implementation. Now, the third level, where people may become involved much more readily, is the level of common law, which is litigation, and in the Queensland context, that will usually be the Planning and Environment Court for development applications, or it may be the Land Court for issues to do with, say, mining. But it's not every decision of a council or an assessment manager that may become the subject of litigation. There are some special rules that apply. Now, essentially, you need to be a party that is affected by that decision. It's pretty easy. If you're the applicant in a development application and you're unhappy, either because the application was refused or you're not happy with the conditions, then of course you have the right to appeal. And generally that would be to the Planning and Environment Court. But if you're an objector, if you're a submitter, if you're a neighbour or some other party, you may not have the right to go to the Planning and Environment Court and seek redress. When it comes to a development application, essentially for a submitter or an objector, unhappy with the executive decision made with respect to a particular development application, there is a right to challenge only in certain circumstances, and one of the first things is to consider the nature of the application. Specifically, an objector or submitter can only make an application for the Planning and Environment Court to review the decision if it relates to an impact assessable development application. So we'll come across that term a bit later. Don't worry too much if it sounds a bit complicated. It'll fall into place, particularly when we deal with the IDAS provisions, which I think is in about week 5. So an impact assessable development application is one where a submitter or objector has the right to challenge in the Planning and Environment Court. But again, there's certain rules. I mean, you can't just come in at the last minute. You have to have gone through that objection process within the time limits before you have the right to go to the P&E court to challenge various decisions. Okay, so what we're talking about now is the common law, which is litigation, and specifically litigation in the Planning and Environment Court. In order to determine the impact of the common law in Planning and Environment Court, in Planning and Environment Law, we need to bear in mind that the decisions of the court relate to various different legal matters and are dealt with in different ways from a legal perspective. Most of the decisions that you'll read about in the course in the Planning and Environment Court relate to what we call merits appeals. A merits appeal is one where essentially, as we say, the Planning and Environment Court steps into the shoes of the assessment manager, and that's usually the council. Okay, so let's be more specific. We have, let's say, an impact assessable development application considered by the council, which is the assessment manager. The assessment manager may say, yes, I'm happy with this, I'll approve the development, but there may be some opposition. Submitters may take the matter to the Planning and Environment Court. Or the assessment manager may say, I'm happy with the development, but I'm going to impose certain conditions, and those conditions may be the subject of opposition, either from the developer or from submitters. Or the council might refuse the application and the developer might go to the court. So the Planning and Environment Court then considers the matter, not necessarily every matter, but generally matters involving impact assessment development. Now, if you want to know what impact is all about, have a look at the Sustainable Planning Act section. Schedule 3 of the Act provides a definition of impact, and that might provide some light as to what we're talking about. But don't worry too much. We'll deal with this in about week 5, and there's a lot of material. If you want to start reading ahead, it'll give you a good idea. So I've mentioned in the Planning and Environment Court, we have this thing called merits appeals. And I need to explain that briefly and also contrast what a merits appeal is to other types of matters that might be considered by the court. So a merits appeal, as I mentioned before, is where the court sits in the shoes of the assessment manager, so to speak. What that means is that the court is charged with the responsibility of making what we call the correct and preferable decision in relation to the matter, and it does so by hearing the matter afresh. The court has a responsibility to determine the application on its merits, which is why we call it a merits appeal. It's not a case of the court focusing on what the decision maker did or the process by which the decision maker, as the assessment manager, came to its decision. That's not what a merits appeal is all about. A merits appeal is essentially saying we're tossing out what the assessment manager decided completely. We're starting again, we're filling the bathtub up with new information, and the court will make the decision as if it's part of the executive in the merits appeal jurisdiction. So that's what most of the cases that you'll read about relate to. They relate to the court coming to a decision which is the correct and preferable decision, and that will be instead of the original assessment manager's decision. So that's a merits appeal, but what other types of appeals are there? So you may come across a judicial review. Now, a judicial review is very different to a merits review, and it is important that you understand the difference between the two. So a merits appeal is where the court considers the matter on its facts and makes a decision on its merits. It's the final arbiter of the merits of the decision. A judicial review is where the court is asked to consider essentially the way in which the decision maker went about making his or her or its decision. Let me be more specific. So if a decision maker clearly shows bias or refuses to listen to a party and doesn't provide them with natural justice and an opportunity to be heard, for example, or does not have power. I mentioned that the decision maker can only receive power if that power is delegated to it. If the decision maker doesn't have power, then that's a right of challenge. And all of those things, bias, lack of power, which is ultra vires, failure to afford natural justice, they're all matters that are subject of judicial review. The court in that instance doesn't make the decision about whether the application should be approved or not approved or what conditions should be imposed. It's purely looking at the way in which the decision maker made its decision and asks the question, did the decision maker have power to make the decision according to law? Okay, so merits review, the court makes the decision. Judicial review, the court considers the manner and legalities about which the decision was made. Gee, I hope that makes some sense. It's all a bit technical, but if you've got any issues or any questions about that, please let me know. All right. Now, in the context of the Planning and Environment Court, the important legislation initially is the Sustainable Planning Act, and the Planning and Environment Court, as I mentioned, is part of the District Court. Now, bear in mind that in Victoria, there is no Planning and Environment Court as such. Applicants for planning permits deal with those issues in the Victorian Civil and Administrative Tribunal, which is counterpart of QCAT, where I'm a member. Okay, let's progress. Now, credit John, I've mentioned, and I think this is the video for week 3, an excellent video involving Rod Lister QC. He represented one of the parties in that litigation, and that's really worth a look because Rod goes into a lot of detail and he provides some excellent commentary in terms of merits appeal, processes, the types of conditions imposed, things of that nature. So I'd urge you to have a look at that. And I'm very grateful to Rod to provide his time and expertise for me in that regard. The other thing is that I've placed on UCrew some extracts from John Carvin's book. This is a Thomson Reuters publication, John Carvin, called Understanding the Australian Legal System. And I've quoted some comments from page 39 and pages 60, 61 and 62. And essentially what Mr. Carvin does in that commentary is explain really well what we mean by delegated legislation and, very importantly, why we have delegated legislation. And bear in mind, of course, that the Council has no power to make these rules, regulations, bylaws or planning schemes unless that power is given to it by Parliament. And we call that delegated legislation, and that's what is contained in that commentary. Okay, now tonight's heading is common law, so let's go back to that more specifically. So common law is the law made by the courts, and prior to the prevalence of legislation, the most important part of planning and environment law, which is really a new discipline, but was common law. You know, we'd look at what did the judges decide in determining what the law is in a particular instance. But of course, legislation becomes more and more prevalent, and you'll remember that legislation overrides the common law. So increasingly, the most important part of our primary source of law is legislation. The common law, the judge-made law, is secondary to that, both in terms of its prevalence and also its rank. Legislation overrules common law. So in some ways, tonight's material is less important than what we have discussed over the first 2 weeks. However, it's still important to understand that common law has its place in planning and environment law. And bear in mind, of course, as we mentioned, I think last week, when you're looking at a deed of grant of land, freehold, bear in mind that there are restrictions, and one of the important restrictions is in relation to mineral rights, and there's legislation on that. But subject to legislation that affects title, the common law always tries to protect the rights and interests of landowners. Traditionally, that's the case. But given that legislation overrules the common law, the role of the courts in that regard has become less important. So there is a conflict between legislation and common law rights. common law rights, a landowner essentially has the right to do whatever he or she wants with the land, subject to other common law principles. So there's a conflict there. And here's really the element of environmental law, planning and environment law. It's for the greater good to protect the environment. But sometimes, in order to do that, legislation must curtail, limit, restrict the rights of an individual landowner to use their property as they see fit. And that's contrary to the common law. So we have that conflict between legislation and common law. And typically landowners oppose legislation because the legislation which is designed to promote the protection of the environment will often provide a corresponding constraint upon the landowner to do something with the land. Vegetation management legislation, for example, is a prime example of that. Last week, you might recall, we talked about Spencer's case and the comments made by His Honour in that case that sometimes the laws that are created for the benefit of the environment generally have the effect of causing individual landowners to suffer loss. And if those landowners are not compensated, the introduction of the law in effect says that an individual must suffer a loss for the greater good. And His Honour was making comment to the effect that that isn't necessarily a fair system. So just take care when you're dealing with government agencies in an executive function perspective. And if a promise is made by a government agency during the negotiation process, if that fetters the future exercise of statutory discretion, then it is void. Have a look at Cudge and Rutile against Chalk. It's 1976 Appeal Court, 520. All right. I'm just going to mention two common law actions that are very important, very well established, and to some degree have a bearing on planning and environment law. The first is negligence and the second is nuisance. So negligence. Negligence is a concept that essentially was created in about 1930, 32. It's the whole Donoghue and Stevenson thing. But essentially it comes down to this, that if a person acts in a manner that is causes loss to another, and that loss is reasonably foreseeable, then if that person does the activity or fails to do an activity that causes the loss and it's reasonably foreseeable, then they're negligent and they're responsible to their neighbour. So, you know, a manufacturer making ginger beer allows a snail to go into one of the bottles. The customer opens that bottle, drinks the ginger beer, gets sick. The negligence in allowing that snail to get into that ginger beer bottle caused injury or loss to someone, and it was reasonably foreseeable that the activity, the action of allowing that to occur was likely to cause some loss. Therefore, the person who suffered is entitled to claim for negligence. So that has a planning and environment court perspective as well, in the sense that if someone uses their property in such a way as to cause reasonably foreseeable injury or loss or damage to someone else, then that other person can sue the owner for negligence. The other thing, and this is covered in Bates's book very well, is nuisance. And nuisance is where, from a P&E perspective, say there's an environmental hazard, noise or fumes or smoke or pollutants. If those escape, as it were, onto a neighbour and there's an effect onto that neighbour, then that can be actionable as a nuisance. The case to have a look at there is Ball against Consolidated Rutile, 1991. It's 1 Queensland Reports 524. In essence, what happened is this. The defendant was a mining company conducting some sand mining operations on North Stradbroke Island, Straddy, and it formed a sand dune. That slipped, caused significant erosion. The sand, the soil, the vegetation, it all went into the waters of Moreton Bay. Now, the plaintiffs, commercial fishermen, professional commercial fishermen, sued the mining company in negligence and public nuisance because they said, look, we have suffered a loss, our gear is damaged as a result of what has happened. We can't use our nets, and that's an interference into our work, so that's a nuisance, that's a negligence. Ultimately, the court disagreed, but it's a good example of how environmental action can create a common law case or a request for a common law remedy, in this case, both nuisance and negligence. But it was unsuccessful, and it's becoming less prevalent. So if you're thinking about taking action from a planning and environment court perspective based on a tort, such as nuisance or negligence, you might also think about whether there's some statutory remedy as well. And that statutory remedy might look like a criminal law type matter. For example, have a look at section 319 of the Environmental Protection Act, and that deals with the concept of a general environmental duty. And what it says is this: a person must not carry out any activity that causes or is likely to cause environmental harm unless the person takes all reasonable and practicable measures to prevent or minimise the harm, and we call that the general environmental duty. So if you have, in this case, Cudgeon Rutile, an action that's based on a breach of the general environmental duty, then you might be successful, because it may be that it's not a nuisance and it's not a negligence of common law, but there is a statutory provision that can be relied upon in successfully making a claim. And the reason I'm mentioning this is that you need to ensure you don't have the blinkers on and think, oh, well, this is negligence, this is nuisance, and ignore the statutory provisions. Of course, it works in reverse as well. So in answering a legal problem, you may find it necessary to raise a number of issues. This is a statutory issue that might be relevant. Here is a common law principle that might be relevant as well. And that's what I mean about not keeping the blinkers on, because it's too easy to miss a whole area of law that may be relevant to your case if you don't. Okay, in terms of delegated legislation, we've talked about that briefly. I've uploaded some material from Carbon onto UCrew. Have a look at that. In terms of separation of powers, which is last week's problem, I've added some comments. Do have a look at that. And in terms of the issue for tonight of the impact of the common law on planning and environment law, have a look at chapter 3 of your text, and please make an attempt to answer problem, I think it's 3.0 in your material, and we'll talk about that next week. All right, so next week we're on again at 7:30. It'll be a joint session with another class that I have, so we'll see a few new faces. Now, before we leave, are there any questions? All good? Okay. Thank you very much for your patience tonight. All the best. Please keep up your reading, get into your assignment work, and we'll see you next week. All the best.